So this morning, a 16-year-old male was arraigned in front of Judge Egan in the youth part of county court here. And again, that youth part, let me just explain that. It's the youth part of adult court. That's probably the best way to describe it in layman's terms. It's the youth part of adult court, so we're not in family court. We are still in adult court right now, but albeit the youth part due to his age. He was arraigned on 4 counts of manslaughter in the second degree, 1 count of assault in the first degree, 1 count of assault in the second degree, and criminal possession of stolen property in the third degree. If you recall, the criminal possession charge was the only charge that was initially done in this matter on the day that this happened, back on October 24th. After the initial arrest, we put this matter immediately in the grand jury, and we came out now with the new charges of manslaughter and assault. I have 2 separate charges of assault. They both pertain to the 14-year-old female passenger who was in the front passenger seat, who survived this horrific motor vehicle accident. The legal theory on the assault in the first degree is on a furtherance of a crime. So my allegation is that he was in possession of a stolen vehicle and driving around a stolen vehicle, and in furtherance of that crime right there, an assault was allegedly committed. So that is my legal theory on the assault in the first degree, and then the assault in the second degree just pertains to the injuries that the passenger had. She was in the trauma care unit for a couple of days following this incident. She is now out, doing better, but she still has some significant scarring and other bruises and whatnot to her body. And so I'm alleging that those injuries qualify under assault in the second degree. So due to the fact that he's 16 years old, what happens now is that it comes back in 6 days. So it'll come back now next Monday, November 28th. And at that time, we will argue to the judge that a motion does not need to be made, that the matter should remain here in adult court and not go to family court. Under the Raise the Age law, the guidelines are if you can show either use or display of a firearm, if you can show a sexual offense, or number 3, you can show that significant injury, physical injury was done. In this case, I have death, so I should be able to qualify under that legal theory in order to keep this case and not have this case go to family court. A judge obviously could disagree with me. The judge could make me file a motion, and that motion would then be heard 30 days from now. But hopefully, we will not have to file that motion, and hopefully on Monday we can just get a ruling that this matter meets the criteria and therefore should be kept here in the youth part of adult court. The highest charge here is not the manslaughter. The highest charge here is, in fact, the assault in the first degree on the passenger, believe it or not. I tried, well, I should say, I looked at a murder charge here under the depraved indifference legal theory. I could not reach that theory under the law, so the most that I could charge here was manslaughter. But I do have a violent felony in the assault in the first degree, and the maximum on that is 25 years. So again, this 16-year-old obviously is innocent until proven guilty. These are just allegations, but we have had a horrific motor vehicle accident where 4 of the 5 passengers died as a result of the motor vehicle accident. I'm not going to tell you what the exact, well, we don't know the exact speed limit, but we have a pretty good idea of a ballpark speed limit. That number is a result of testing that was done, and under my ethics rules, I'm precluded from telling pretrial what the results of testing are, so I can't give you a number, but I can tell you that the allegation is that he was speeding and going at an excessive rate of speed. If you know that off-ramp of the 98 coming up to 33, there's a concrete barrier there that kind of is in between the 98 and 33. The allegation is that he was going so fast that he kind of rode up onto that concrete barrier and then came around the turn and then hit the second concrete barrier that is there on the actual on-ramp itself. When that car hit that second barrier, it kind of flipped up backwards, allegedly. The Kia Sportage had a sunroof that encompassed the entire roof of the car, and all 5 passengers were ejected and flew out of and crashed through the sunroof. The front seat passenger miraculously survived. Of the 4 who were in the back, so the 14-year-old girl who survived was sitting in the front passenger seat. There were 3 individuals that were in the back seat, and 1 individual was in the back, which is not a seat, but it's a cargo area where I put my golf clubs, and a person was sitting back there as well. And again, like I said, all 5 were ejected through the sunroof, which encompassed the entire roof of the car. 3 were dead at the scene, and 1 went to ECMC and was pronounced dead at a later time. And like I said, thank God, the 14-year-old girl who was in the front passenger seat survived. This accident happened at about 6:45 in the morning. The other 14-year-old girl who was deceased was allegedly at the 14-year-old girl who survived house, and they were picked up about a half an hour prior to this, allegedly by the defendant at 6:15, and they drove around for a half an hour before the accident occurred. I cannot prove who stole the car, so that's why you don't see a stolen possession charge here. I just can prove, well, I think I can prove, obviously, it's allegation. I think I can prove that he was in possession of a stolen vehicle, but I cannot prove who stole the car. The car was stolen the previous night, on Sunday night, from the parking lot of the Marine Drive Apartments here in downtown Buffalo, where the owner of the vehicle lived. The defendant was out on bail after the initial arrest on just a stolen possession charge. He was out on bail under what we call release under supervision. The acronym for that is RUS, R-U-S. At the time of the initial arraignment on the arrest, the judge at that time released him with certain conditions about curfew, going to school, et cetera, et cetera. The probation officer came into court this morning and told the judge that the 16-year-old defendant was abiding by the conditions of the release, and the defense attorney asked the judge for a continuation of that release under supervision. I vehemently argued against that and argued that he should be remanded and put in jail. I made a kind of an off-the-collar comment, 3 weeks ago at the arraignment here, that I didn't think it was right that this kid is out playing video games and there are 4 other kids who are dead, and I still don't think it's right that this kid is out playing video games when on Thursday at Thanksgiving there's going to be an empty chair of 4 individuals at the Thanksgiving dinner table because their loved ones, their family members are not going to be eating Thanksgiving because they are deceased. And this kid is now out. So we argued that, and to no avail, obviously, and the judge continued the release. I think that's it. David.
Yes, sir. In court, it was stated in court that this defendant, Mr. Armstead, is now considered an adolescent offender and not a juvenile offender.
Yeah.
Can you explain what that means?
Yeah, it's just a technicality. So it's an age thing, okay? The 16 and 17-year-olds are considered adolescent offenders, and 15 and below are considered juvenile offenders, okay? That it also changes whether or not you're actually in the youth part or whether you're not in family court. So if you're in the youth part, you are an adolescent. If you go to family court, then you become a juvenile. It's just a technicality.
There used to be juveniles being tried as adults. Is that the case here?
That's gone now. Under the Raise the Age law, that acronym is now gone. So now it's all, under the new Raise the Age law, now it's juvenile offenders, adolescent offenders, and they all have different rules and regulations.
Are you seeing an increase in thefts of Kias now that kind of the secret's out with this TikTok challenge?
Yeah, no, it's kind of gone down. It's kind of gone down now. I mean, the cat's kind of out of the bag now. I'd have to talk to Joe Grimaldi about exactly how many we've seen since then, but I heard initially that it has gone down now.
And do you think there's still a possibility for a lawsuit, New York State lawsuit against Kia?
I don't know yet. That's Attorney General's office. I mean, I wouldn't be involved in that, obviously. That would come from the Attorney General since they handle the civil nature aspect of that. Yeah, I don't handle anything civil.
And one more Kia question.
Oh, yeah.
They started handing out the wheel locks,
yeah,
or whatever those are. I know it's Amherst or Cheektowaga. Do you feel like that's enough?
No. No, it's not enough. I mean, you're putting a Band-Aid on a problem. Fix the problem. Okay. The problem is the actual ignition. Okay. From my, again, I'm not a car expert. From my understanding, it's very easy to just pop the compartment over the ignition on these Kias, and then once you pop that off, then you can just, like I said before, you can just stick a regular old, fob into the ignition, and it turns on. So obviously, they need to fix that problem, and a Band-Aid solution of, car locks, is, like I said, a Band-Aid. Yeah, David.
So in a lawsuit, a civil suit, where a lawyer representing families of 2 of the decedents in this accident is suing, interestingly, Kia, not the person who allegedly was driving this stolen vehicle.
Yep.
However, in there, he says the crash occurred at 100 miles per hour. Are they wrong?
I can't confirm that. Yeah, I know. I can't. I can't. Yes, I can get in trouble. That you're trying to get me disbarred. I can get in trouble. Yeah, I can't. I'm specifically precluded from telling the results of any testing that was done in a pretrial environment. So yeah, I can't confirm or deny that. I just tell you, he was going real fast.
In moving for the continuance of his release under the prior terms, the defense lawyer, Mr. Genovese, noted this individual is 16, no prior record, he lost his close friends, he's hurting and suffering every day because these were his loved ones.
Again, I get that. I am not a mean person. I think everyone knows that. Okay, I'm not a mean person. I get that he's 16 years old. I am the father of 5 kids. They're all past 16, but I had 5 16-year-olds at one point. I am not here to jam up a kid. However, this was a horrific incident. This incident resulted in the lives of 4 kids being taken. And there are there are bars in life, in my opinion, where if you cross that line or you cross that bar, then stiff penalties, stiff conditions, and quite frankly, harsh realities need to take place. And in my opinion, this crossed that line, and this exceeded that bar, and therefore, this individual does not deserve, in my opinion, to be spending Thanksgiving while 4 of his dear friends are not here to spend Thanksgiving. That's just my opinion.
Have you connected this definitively to the Kia,
No.
No. Is there video evidence that they took? Or?
No, I haven't 100% definitively. We're probably never going to know that. But I'm 99% there. Yeah. Okay.
People might be a little bit confused why an assault charge carries a stiffer penalty than a manslaughter charge.
Yeah.
4 lives lost.
Yeah, no.
So people would think that would carry a harsher penalty than an assault charge. Can you explain that, why that carries a stiffer penalty than a manslaughter charge?
Yes, sir. So every charge in New York State is codified in the New York State penal law. Every charge is given a class in the penal law. It's either Class A, Class B, Class C, or Class D, Class E. So there's 5 classes, A through E, in our state statute. The New York State Legislature, who drafted the statutes, they codified manslaughter in the 2nd degree as a Class C felony. That's just per the statute. The reason why it's 2nd degree is that that's under the reckless theory. Manslaughter in the 1st degree is under the intentional theory. So there is no evidence to prove that he intentionally meant to kill anyone or intentionally meant to hurt anyone that resulted in the cause of death. So the evidence that we have is that his actions were reckless, and the recklessness resulted in the death. So that's the evidence that we have, and so that fits perfectly under the manslaughter in the 2nd degree. But again, New York State has codified manslaughter in the 2nd degree as a C felony, and that's just the people who wrote the statute years ago. Yes, Kevin?
Do you happen to know where they got on the 33?
No.
Where did they enter the 33? We know where it ended, but where did they get on it?
I don't know. If Kamalia knows, I'll call him, and Kate will tell you. Okay? Yeah, Kate, you don't know off the top of your head, do you?
No, I don't.
Yeah.
So did you, on the assault first, was the theory that he injured someone while committing a felony? Is that the...
Well, committing a crime. It doesn't have to be a felony per se. It just can be in furtherance of a crime.
For an assault first?
For the assault first, yeah.
Felony, doesn't it?
Well, no, the assault first is a felony, but the underlying crime doesn't have to be a felony, okay? So the assault on the assault first, there's a subsection that says if you are in furtherance of a crime, the underlying crime being possession of stolen property, driving around in a stolen car. That's the underlying crime, okay? If you're in furtherance of that crime and someone is injured, then it's assault first. No, the underlying crime does not have to be a felony. It could be a misdemeanor. It could be so if in furtherance of a misdemeanor, yeah. But normally they are felonies, though.
Can you go over again just the path of the car, how it hit? So went past those yellow.
Yeah. So after those yellow so if you can picture in your head, after those yellow cones, there's kind of like a concrete median that's there. Okay. It went up on that concrete medium, on top of it, and kind of slid around, and then there's a second concrete barrier there that's kind of on the curved wall there, and it hit that.
Your office being able to talk to some of the people on the road that day. I'm
Yes.
sure they're horrific to see a car ahead of you with bodies flying out of it.
Yes, we have. Yes, we have. We've talked to anyone who Witness this. We have talked to numerous people, yes. And obviously, I don't know if any of them actually saw the bodies flying out of the car off the top of my head. But obviously the first responders who showed up, it was one of the most horrific scenes they have ever seen.
How far were those bodies?
Off the top of my head, I don't know, Maki.
Have you been able to talk to the victim? Because I know that, or not the victim, but the survivor. I know that was a key
Yes.
point in your investigation.
Yes. Yep. Yep.
And just to clarify, there was 5 bodies that were ejected, because I think when this originally was 4, but all 5 of the passengers
Yes.
and the driver were ejected.
Correct. All 5 of the passengers were ejected.
And the driver was?
Driver was not. The driver's airbags went off, and the steering wheel was there. So I'm assuming now that the steering wheel and the airbags kept him in the car and did not go out.
Just so we're clear, the fellow we saw in court was the driver.
Yes.
The adult, juvenile, adolescent thing. So technically right now, he is still considered a what?
He is an adolescent offender. So he is right now in the youth part of Superior Court, which is adult court. And so I am going to try to keep this in that part, but it's ultimately up to the judge as to whether or not it leaves me and now goes to family court. I'm going to fight that tooth and nail, obviously.
For media purposes, he is still considered an adolescent and his identity is still not to be released.
Yes, correct, yeah. So his identity is not. I'm never going to release his identity. I mean, here, if you find out about it through other means, I mean, that's up to you whether you want to put his name out there. I mean, but due to the fact that he's under age of 18, I am not going to release his name ever.
The conditions of his release today are the same as
Yes.
they were before?
Yes, curfew, go to school. There were some other things too. Yeah, whatever.
I don't know how much you can describe just the difference between if he stays in the youth part of the Erie County Court here compared to what kind of happens next if he does go back to family court. Does that change?
It's a massive change. It's in family court. First of all, there's no prison in family court. They send, you can go to these youth detention centers. They have specialized facilities for those who are under the age of 18 years old. Now again, even if he stays with me and he ultimately does go to prison, okay, he's not going to be housed with adults, all right? So there's still a delineation there and a separation there, but the rules are just 1,000 times laxed in family court than they are in regular court.
Well, is it still the case where someone goes in and they aren't housed with adults, but when they become an adult, if they're still guests of the state, don't they get housed
Yes,
with adults?
correct. Yep.
And sentencing is very different.
The sentencing is huge. Difference. The sentencing is different. I mean, yeah. Now again, just to be fair here, he could stay with me and stay in adult court, the youth part of adult court, and he could get YO, youthful offender status. And if he gets youthful offender status, that changes the sentencing as well, and the sentencing goes down as well there. So there's the possibilities for this kid are family court with very minimum sentencing options, stays with me in adult court and gets youthful offender status, which also reduces the sentencing, or number 3 is stays with me in adult court and does not get youthful offender status and is sentenced as an adult. That's what I'm shooting for.
John, real quick,
Yeah.
if you don't mind,
Yeah.
I know yesterday was supposed to be the plea deal for the sentencing for the top mass shooter, but
Yeah.
obviously with the weather that got
Correct.
pushed back.
Correct.
There was a report that that's happening on Monday. Can you confirm that?
Yes.
Monday?
Correct.
So
Yep.
I know you can't really say much.
I can't say anything. I'm under a gag order. So Dave was trying to get me disbarred about half an hour ago now, so I can't let you either now. Okay, but I mean, all I can confirm is that the courts were closed yesterday, so it got obviously canceled, and now it is scheduled for next Monday at 9:30.
Can you maybe just describe after the plea on Monday, what kind of happens then next afterwards, kind of that proceeding?
Well, again, I don't want to presuppose that it's going to happen, okay? Because again, people can change their mind, okay? But put aside that specific case. Let's just talk about like this case or any case in general. What generally happens after an individual pleads guilty, then the judge will give a date for sentencing, which is usually 30 to 60 days out, okay? And then so after a guilty plea on X date, the judge will schedule a date for sentencing at a later date. So that's what happens in every case.
So that court date is the same date as this youthful offender court date as well, right?
Yeah, it is. Yeah.
Is that going to be extra? I mean, I guess. What are your thoughts on that? Is it?
No. Yeah, I didn't even think about it until you mentioned it. Yeah, no, it's fine. Yeah, no. Hey, it is what it is. We'll have to just deal with it. Yeah.
So I'm sure the media will be looking for you.
Yeah. I'll be around next Monday. Yeah.
And then are you?
I'm not going golfing. Yeah.
At that point, with the plea, then, for your sake, would that open things up, or are you still under the gag order then at that?
Oh no, I'm done. I will, as soon as the plea is done, I'm gonna have a special room downstairs, in another courtroom, and you can ask. I can talk anything you want. Yep, I'll fire anything you want. Yep. I'm still under gag order now, though. Yeah, so don't get me in trouble.
Yeah.
Jeez, man. I don't. Yeah.
Thanks, John.
All right, no problem. Thank you. Okay.